Okay, first thing I'm going to do this morning is the reason that I do this right here um, is solely to get the word out, to educate the public on issues they may not know, you know what I'm saying, that I think are essential in life, primarily I live in the United States, so American civil law and criminal law. In return, psychology. But right now we're focusing on law. And, this is kind of unorganized. I wish I had all my stuff together and I had all this organized and I could really sit down and I could really, try to educate you, teach you, in a proper way. But I'm just kind of winging it right now until I get there, And so what I will do right now is what you got to realize, that the same standard, the criminal standard of reckless disregard, is the same standard used in civil rights cases, in civil lawsuits, okay? And so if the definition of reckless disregard in Arkansas is a person acts recklessly with respect to attendant circumstances or a result of his or her conduct when the person consciously disregards a substantial and unjustifiable risk that the attendant circumstances exist or the result will occur. Now, when it comes to Arkansas battery laws, criminal violations, whatever, ultimately they have to show that you did something in a wrong way, you know what I'm saying? And that ultimately you acted in one aspect or another with reckless disregard. That's the same criminal standard that is used in excessive force cases in our civil law, okay? Let me go down a little bit. Recklessness is a higher degree of culpability than negligence or gross negligence, but less than an intentional wrong. So that, okay, let's see, like ACA, Arkansas Code Annotated, subsection 5-2-614, use of reckless or negligent force when a person is justified under this subchapter in using physical force, but he or she recklessly or negligently injures or creates a substantial risk of harm. Okay? So you might have been justified all day in the amount of force that you use by law. Say you're law enforcement, right? But when you either recklessly or negligently, let alone maliciously and sadistically intentionally, okay, commit, battery, you know what I'm saying? Then that's not only a state criminal law violation, that's excessive force and violates your civil rights. If y'all watch that video with, I think his name is Zach, what's his name? Jason Colt. That guy. I don't know whether that dude headbutted him or how many times that dude headbutted him or anything. I don't know nothing about that. Now, we can say that he did all day, and we gonna say that he did, all right? All right. Check this out. If you look up, let me look this up real quick. Well, I'm not on that one, so I'll read this one first, actually. Oh, that's battery in the first degree. Let's go over here. Okay, right here. All right. This is Arkansas Code Annotated, subsection 5-2-610. 5-2-610, use of physical force by law enforcement officers. A law enforcement officer is justified in using non-deadly physical force or threatening to use deadly physical force upon another person if the law enforcement officer reasonably believes the use of non-deadly physical force or the threat of use of deadly physical force is necessary to 1. That's the only circumstance, and that's what he can do, okay? 1, effect an arrest or to prevent the escape from custody of an arrested person unless the law enforcement officer knows that the arrest is unlawful, or 2, defend himself or herself or a third person from what the law enforcement officer reasonably believes to be the use or imminent use of physical force while effecting or attempting to effect an arrest or while preventing or attempting to prevent an escape. Now, B, a law enforcement officer is justified in using deadly physical force upon another person if the law enforcement officer reasonably believes that the use of deadly physical force is necessary to 1, effect an arrest or to prevent the escape from custody of an arrested person whom the law enforcement officer reasonably believes has committed or attempted to commit a felony and is presently armed or dangerous, or 2, defend himself or herself or a third person from what the law enforcement officer reasonably believes to be the use or imminent use of deadly physical force. That's it on deadly force. You know what I'm saying? And that's that whole statute right there. But these are the only reasons that you can. So now if a dude headbutts that guy, now hold on, I gotta go back to another statute, right? It's gonna be right. Let me bring up this statute real quick. It's gonna be ACA subsection 5 -2 -606. Now that's why I'm gonna sign in this daggum thing. I ain't got no password. I'm not no law library, but I did have it. Okay, this is Lexus. So let's go over here. Well, shit. Actually, I can do it right here. 5-2-606. All right. Okay. No. Yeah. All right. So now. All right, Arkansas Code Title 5, Criminal Offenses, subsection 5-2-606, use of physical force in defense of a person. So this means this isn't law enforcement, this is anybody, okay? This is the use of physical force in defense of a person. For you, for me, for anybody. And what it basically, I'm about to read it, but what it basically says is the same thing 5-2-610 just said about law enforcement. Meaning that they don't have no more rights to use any more force than we do. Except under the 2 circumstances that, that somebody's trying to escape or commit a felony or committing a crime. You see what I'm saying? We can't arrest them. You dig what I'm saying? But that's the only things that they have on us. Let me read this statute. A1. A person is justified in using physical force upon another person to defend himself or herself or a third person from what the person reasonably believes to be the use or imminent use of unlawful physical force by that other person. And the person may use a degree of physical force that he or she reasonably believes to be necessary. 2. However, the person may not use deadly force except as provided in ACA subsection 5-2607, which under that circumstance, if you read these, you could be justified in deadly force. But this is 52606, not 52607, and so I'm going to finish this one right here. B. A person is not justified in using physical force upon another person if, 1, with purpose to cause physical injury or death to the other person, the person provokes the use of unlawful physical force by the other person. Meaning that if I have a purpose to cause physical injury or death to another person, and I provoke them and say, come on, let's fight, and then I hurt them, that's not justified. That's what that simply put meant. 2A, the person is the initial aggressor, meaning that I'm the one that initially came at you, like I just said, but moreover, I hit you. So if I hit you, now let's just finish the thing. So if I was the initial aggressor. B, however, the initial aggressor's use of physical force upon another person is justified if I, the initial aggressor in good faith, withdraws from the encounter and effectively communicates to the other person his or her purpose to withdraw from the encounter, and the other person continues or threatens to continue the use of unlawful physical force, or 3, the physical force involved is the product of a combat by agreement, not authorized by law. So I'm going to break that down. The initial aggressor's use of physical force upon another person is justified if the initial aggressor in good faith withdraws from the encounter, effectively communicates to the other person his or her purpose to withdraw from the encounter. So if I run up to you and I just hit you one time, right? And then you get mad, and then I'm like, all right, I'm good. You know what I'm saying? Just for instance. You know what I'm saying? At that time, I withdrew. So as soon as you hit me, you're just as wrong as me. You see, and that's another thing with these law enforcement people. They don't even they find out two people are fighting. They want to be quick to arrest both of y'all for at least battered third degree. Which, I mean, technically y'all both might be, but then again, you might not. But of course, I mean, I'm not going to snitch. So ultimately, I'm just going to keep my mouth shut and, submit to restraints if I get in that fight and get caught up. But it is what it is. But by law, you see what I'm saying? That may not even be the case. Like, you might have hit me and you might have started beating my ass and I was fighting back and the police got called. I ain't did nothing wrong. Or vice versa. I might have just pulled up on you, started beating your ass. You was fighting back, defending yourself pursuant to this law. And I never stopped. I just kept beating your ass. And so you was just defending yourself by law. You're not guilty of nothing, but they still want to throw us both in jail. I'm saying that's what they do. Now, the other person continues or threatens to continue the use of unlawful physical force. So now, if I withdraw and you continue to hit me, this, that, the other, you then become the initial aggressor. Like I say, you're just as wrong as me. But since I stopped, and now you kept doing, you was the one that was wrong. So that's what that's saying right there. So now 3, the physical force involved in the product of a combat by agreement, not authorized by law. That's just simply saying that if you and I decide that we gonna meet up somewhere and we gonna fight, or if we got some underground, fight night or something, you know what I'm saying? We got about 3, 4, 5, 6, you know what I'm saying? Different matches, whatever. For the night, that's unlawful. You're not supposed to do that. So therefore, everybody gets in trouble. You see what I'm saying? That's what that's saying. Now, number 3, the physical force involved. Oh, that's what I just read. C, a person who uses or threatens to use physical force as otherwise permitted under this subchapter does not have a duty to retreat before using or threatening to use a physical force if the person is 1, lawfully present in location. 2, not engaged in criminal activity that gives rise to the need to use physical force. And 3, not engaged in any activity in furtherance of a criminal gang, organization, or enterprise as defined under 574-103. But of course, what that one right there says, if you're lawfully present in location, say it's your residence, and somebody comes up on there, then yeah, but see, those are other codes too. That's going to be, this 52606, so that's going to be like 52607 is the use of deadly physical force in defense. So, I think it might be 52608 and 52609 that talks about your property and premises, and I'm not even really trying to get into all of that, but there's uses of physical force and defense of your person, of others, your property, and all of that, that I'm just focused on use of physical force in defense of a person right now. I'm not focusing on any of that. But there's laws that give you those rights too. And this right here just basically says that without getting into that actual statute. Lawfully present in the location, not engaged in criminal activity that gives rise to the need to use physical force. So say you're not selling drugs, you ain't selling stolen merchandise, whatever. You ain't doing nothing wrong. You can lawfully be there wherever you're at. Somebody comes at you and you got to, defend whatever. Okay, cool. And you're not engaging in any activity further in your criminal gang, organization, or enterprise, then, yeah, you're justified in the threatening of physical force, and possibly even using physical force to let somebody know that they're not welcome there. Anyways, but let's see. So now, like I say, when that dude headbutted Jason Cole, however many times he did this, that, the other, whatever. But you see in that video, Jason Cole says, "Oh, you want to headbutt me?" Pop, 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 pop. Now, if you can understand this right here, convicted prisoners are protected from the misuse of force by the Cruel and Unusual Punishment Clause of the 8th Amendment. The Supreme Court has held that whenever prison officials stand accused of using excessive physical force in violation of the Cruel and Unusual Punishments Clause, the court judicial inquiry is whether force was applied in a good faith effort to maintain or restore discipline, or maliciously and sadistically to cause harm. When you see Jason Cole being mad, oh, you want to hit me, oh, you want to headbutt me, and he just starts, hitting the dude. He's mad. That's malicious, and the sadistic intent was when he actually hit the man to cause him harm. You see what I'm saying? So that's blatant right there on the face of that period. Now, we're not talking about criminal law. This is civil law right here. Okay? That period right there shows a civil rights violation. You know what I'm saying? By his own admission. And then he does that. That's a form of retaliation. That's excessive force. Period. But when I'm trying to get into the criminal law, he's committed. If y'all just read this, 52606, and I just read 52610, that goes to show that the man was not justified in the force that he used. You see what I'm saying? Number one. Number two, this reckless indifferent, in order to callous or reckless disregard, okay, in criminal law, is like the standards that you have to use in applying that somebody was doing this, intentionally or without regard. You know what I'm saying? To prove that it was not negligent. In return, that is the same thing that you have to show. You see what I'm saying? In civil law. So basically what I'm saying is that the same standard in civil law for excessive force claims ultimately is actually the criminal component, the criminal standard. So if you can prove that they violated, we'll say, an excessive force claim in the United States, or in a civil rights case, then you set the same standard that they violated some type of state criminal law. It's crazy because, I was looking for it in here and I couldn't find it. So maybe it was in one of the cases I got or I read or whatever, which of course that draws that out. You know what I'm saying? That states just what I just said. And I can't find that exactly. And that's what I was really wanting to use for this. But when I do, I'll be able to show and prove, because I don't like just talking, you know what I'm saying, without being able to show and prove. And I honestly feel like if you got a case that is nothing but circumstantial evidence, that, this man was the last one seen at this address right here. We got surveillance from a stoplight showing this man around the same approximate time. But there's no scientific DNA or anything, evidence like that to show and prove that this man actually did this crime, then that's circumstantial. The circumstance shows that this man was the last person here. So therefore, when they try to charge this person, there's no actual evidence to show and prove it. You see what I'm saying? So people just automatically assume, yeah, he probably did it based off of whatever happened, okay? And truth be told, is, yeah, of course, that's a form of evidence. It's called circumstantial, but that doesn't mean anything. You see what I'm saying? For instance, let me think of. I'll show you well, when I was in prison, I sat up and I thought about lots of different aspects of all of this as I'm doing my research and study. Which, of course, another thing that I'm getting into now is because I wish I had like a good friend that was like a TV5, you know what I'm saying, journalist, and like a TV5 producer or something, man, so I could actually make some documentary films and, do all of this. But I'm trying to learn some video editing and all of that right now. I really don't know how to do all that, so that's why I just got to do what I got to do right now. But one scenario that I came up with in my head was, all right, you got this guy, okay? He's, let's say, 50-something years old, all right? He lives by himself. He's got a daughter. He's got a son. Let's say he got a daughter, all right? So let's start with that. Now, this guy decides he lives by himself. His daughter's grown. You know what I'm saying? And this man decides he's going to go camping, right? He's a law-abiding citizen, never been in trouble. He got guns in his house, all right? Now, this dude goes camping. He tells his daughter he's going camping, okay? Well, then, all of a sudden, while he's out there camping, he's camping, you know what I'm saying? He don't know nothing about nothing. Somebody breaks into his house, okay? And then somebody steals one of his guns. And then winds up killing one of the neighbors 3-4 miles down the road because he lives in the country himself. You see what I'm saying? And he loaded that gun and everything. His fingerprints are all over that gun, this, that, the other. It's on the bullet, and they pull it out. That dude don't have no alibi. His daughter knows that he went camping. That's what he told her. But she wasn't there camping with them. So now they get the ballistics, and they see that this matches the bullet has his fingerprint, all of this, it matches one of his guns, he got registered, this, that, the other. Now he's on trial. That man didn't do nothing. This is a hypothetical case, and under this hypothetical case, the man really was hunting. Somebody really broke into his house. You see what I'm saying? So before he could even come home, find out that a gun was missing, and report it, he might not have even known. He might have several guns for him to even realize one of them was missing. For instance, now he's on trial. And that's circumstantial evidence right there that has scientific DNA on it. But yet, did this man really kill these people or not? You see what I'm saying? That's the question. But based off this evidence, an innocent man just might go to prison. And that's sad. So, like, I like to show and prove my stuff. And I honestly feel like if you don't have a full case, then, and another thing is, my thing is, because I got this Georgetown Law Journal right here. And, like, if I was to read the introduction to this, which I'm not going to do right now, but now I'm sitting back in my head like, hold up, what? Like, a prosecuting attorney is going to get up here and piece the facts together the way that he wants to piece them together. You know what I'm saying? In order to convince a jury that this happened, but yet he was not there. He don't know what truly transpired, but yet he going to say that this or that or the other happened. And you could be straight lying. You see what I'm saying? Slandering somebody's name, assassinating somebody's character, defamation, you know what I'm saying? All of that. And it's sad. And I don't feel like that should be legal. But that's my opinion. I'm going to get into some more. I got other stuff I got to personally do on this legal note. And so I just wanted to kind of share that with y'all this morning. I hope y'all have a blessed day.